Nigeria info.
This is Hard Fact.
11 minutes gone past 4 p.m. It's good to have you once again, listening to 92.3 Nigeria Info, your talk news and sports radio station. And to listen to me, yours truly, Kalada Kurbatabo, it's my pleasure. Welcome to Hard Facts. It is time for us to switch the conversation. And this time, we're going to continue from where we left off yesterday, or what we've been looking at all week. The week just started yesterday, right? So it feels like Wednesday already. But yeah, we're going to be looking at the development in the political space in River State. The Court of Appeal ruling, all of the ruling. But, we're going to look at it in relation to impeachment. I know we've dealt with impeachment before. I think the guest at the time was Henry Ekine. And so, yeah, we talked about impeachment, and he broke it down for us. The processes, there's a sitting where, where the lawmakers attempt to define the governor's gross misconduct, and then they transmit a letter of impeachment to the governor. And then if the governor replies, there's another sitting, and after the other sitting, they send whatever their decision is to the Chief Justice, as if they want to continue with the impeachment process. The Chief Justice or the Chief Judge of the state looks at it and sets up a 7-man committee now, and the 7-man committee is believed to be apolitical. I wonder if they can find those kind of people in River State anyways, but yeah, believed to be apolitical, and then they go in and they make their findings, and they come back with their findings, and then the House will sit again, and then the House will then impeach. Such a long process, I should say. However, the River State government has gone to court, asking the court to bar the Chief Judge of the state, I think Simon Amadi, from accepting any document of impeachment against the governor from the Martin Amaewhule-led assembly. Now, many talking points as it relates to this. There is the issue of legitimacy. There's the issue of the Court of Appeal judgment saying or not saying. There is the issue of whether the governor has indeed committed a gross misconduct. And like I said, the 3 o'clock hour, I need to say it again, the barring of the CJ is an order, is not a judgment. It is pending the determination of the how did they say it again? The motion on notice. I'm fast becoming a lawyer by association, by the way. But let me introduce my guest as a lawyer, Living Gifting Jamala. So welcome, Living Jamala Esquire. It's good to have you on the show.
Thank you. Good afternoon, Kalada, and our esteemed listeners, Rivers and beyond.
All right. So I'm going to start with a very basic question I've been asking everybody who's been on the show in the last 3-4 days. What do you make of the Court of Appeal judgment as it relates to, who is a member of the House of Assembly and everything?
I think basically the Court of Appeal ruling or judgment, if you want to make it that way, took us back to
square one.
I won't say square one per se. Square one started with the members being intact. Square two took us to when they defected, and there was this argument whether or not they still have the legitimate powers to legislate over issues that borders on River State. Those 26, when I say they, I am referring to Amaewhule and his friends.
Okay.
And whether they still have the legitimate powers to legislate over issues that has to do with River State, as provided for under Section 4. Now, when that division occurred, or by virtue of those who belong to the school of thought, that upon defecting from their original political party without meeting the criteria provided for under Section 109 subsection 1G, is to the effect that it became automatic that they've lost their seat. So that is where the legitimacy hangs. Now, if you look at that, the decision of the Court of Appeal only borders on jurisdictional matters.
Okay.
And therefore, every decision taken by, remember the court below, presided over my Lord C.N. Wally, is to the effect that they should stop parading themselves as members of the House of Assembly. Now, that order, having been vacated by the court, has given the Amaewhule-led assembly members the right or the privilege to continue to parade themselves as
now,
members of Rivers State.
Let me pause you now. You have talked about, you have touched on the matter of legitimacy,
Yes.
right? And, you have made reference to Section 109. And,
Sub 1G.
But everybody seemingly refuses to look at subsection 2.
Yes.
Subsection 2 talks about, the speaker being responsible for declaring the seats vacant.
Yes.
And some people, your colleagues, your lawyers, all of you esquires, have been arguing, and they have said that if everybody in a house, for instance, defects, from one party to another, even if there is no division and no merger, who then declares the seat vacant at that point?
If we take the case of Amaewhule and others, where even the speaker, in quote, defected alongside with other members. Now, the House, remember they had earlier suspended some sort of members.
About 3 or 4 of them?
Yes, and those people went to court seeking the protection of the court, and the court allowed them to come back. Now, when the 26 of them vacated their seats, defected, there was a leadership vacuum in the House. And so those who ordinarily, legitimately belong to the House did another round of election by way of bringing in nature abhorred vacuum.
Okay.
So they did another round of election that brought in Edison Ehe as leader of the House. Now, act as the Speaker of the House, acting in that authority, he activated subsection 2 of Section 109.
Okay, so let me agree with you, but is there, you lawyers are a stickler for what is written and what is not written, right? So is there anywhere it is written that there was a automatic vacuum because even the speaker?
Yes.
Because in other cases that references have been made to, other cases that we reference, we've seen that usually the speaker was the one who declared the seat vacant.
That is the procedure, but that of Amaewhule River State Assembly made it very
unique, right?
To the extent that the speaker himself, alongside with others, defected.
Okay.
So if you want to reel out the authorities, as the Supreme Court has so far declared that upon defecting, when you talk about where lawyers are sticklers of the law, yes, what is written down, it is true. In law, when the word shall is used, it derives no explanation from other. It is mandatory. It needs no discretionary powers from another person.
Okay.
So it is mandatory. And therefore, upon taking that decision, you have voluntarily relinquished that right.
But then again, if it says shall and then says the speaker shall to, then is that, anyways, lawyers...
we're looking at the peculiar circumstances that we found ourselves.
So that's why we're waiting.
And so why nature about vacuums? Remember, I said, acting upon an order of court, recognizing this set of persons as members of the House of Assembly, they elected amongst themselves a speaker.
All right.
And activating subsection 2.
Interesting. I like the way you've put it. But now let's go to my next question. If you say that they are no longer lawmakers but are parading themselves, is there any judgment we can hold on to? Because there is the judgment from the Federal High Court sometime in January that did say the government should recognize Martin Amaewhule as speaker.
That judgment that came presupposes that Section 4 gave the powers of the legislation to the State House of Assembly, and they went to reinforce that provision, whether in the circumstances that the institutions of state government, and albeit federal, can stop to deal with the Rivers State House of Assembly are constituted by Amaewhule and co. And the court looked at the provisions of the law, agreed with them. Remember, that suit was also unchallenged. I am aware that the defendant filed some processes, but later withdrew due to the 8-point directive that came from the heavens.
True.
Now, if you look at that, the court agreed with them and said Section 4 gave them the powers. I looked at the doctrine of separation of powers. They are allowed to do so.
But he also mentioned Amaewhule-led's name in that ruling.
That is the Amaewhule who took the matter. They took the matter to court.
Okay.
Trying to reaffirm their own position. But all those things now have been set aside by some of the decisions of court that the other parties have been acting upon those decisions.
But now that's where the next question is. Can another high court give a decision that will now set aside
They are court of coordinate jurisdiction, and none of the decisions of court within this level of government supersedes the other. None sits superintending over the order of other courts.
So that means Federal High Court judgment stands.
The both of them stand.
Interesting. So now it brings us to the next question. I've been wanting to ask the next question, but it seems like you have so much I wanted to tap into. So my next question then is, if both of them stand, then do we need to resubmit or submit, depending on what side you belong to right now, do we need to resubmit or submit the budget to the Martin Amaewhule-led, because they've given a 7-day ultimatum,
Yes.
which is, of course, why we're having this conversation.
If we're looking at it from that perspective, I belong to the school of thought that the 2024 appropriation bill was passed by the assembly duly constituted or recognized by law. It was after the order of court that this set of persons started sitting headed by Ehe. Now, if that being the case, whatever decision that may have during the process obtained by the other factions, if this said appropriation law was duly constituted or duly established, duly passed on by a house recognized by a court of law, in my own understanding, I do not see the need why we should re-echo or we should begin to clamor for passing on a law that already is in existence. Because whatever actions taken by the Edison transferring powers to Jumbo is seen within the eyes of the confines of the law, where we'll talk about the doctrine of the presumption of regularity and yours in their favor. And therefore, we cannot say that Rivers State is operating without a budget. That budget was duly passed, and the 7 days ultimatum given, I remember, it's one of the conditions that came from Abuja.
The Abuja Accord, I like to call it.
Yes, you call it Abuja Accord. I call it the 8-point directive that came from the heavens. So if you look at it that way, it is far unreasonable in the circumstance, if I permit to use that word, to ask that we reenact or we enact a law that is already in existence. So the 7 days ultimatum given there is nothing so serious about it. It's a mere exercise of their freedom of expression.
And not a legal matter, just their expression, their opinion, you say.
They're expressing their own opinion.
All right, interesting. We do have a commercial break coming up. After the commercial break, I've got about 2-3 more questions to throw at you. And one of such is, if you say they don't have a legal backing to be lawmakers, and 7-day ultimatum is just an expression of opinion, then why is the government going to court to bar the impeachment process? I'll be right back. To stay tuned.
And now, hard facts on 92.3 Nigeria Info.
All right, a wonderful day for wonderful conversations, and that's what we're experiencing on the show. Hard Facts on 92.3 Nigeria Info, your talk news sports radio station, and I am your Strudi Kalada Karubat. But with me here in the studio, live and direct, is Living Jamal. Or Jamala Esquire. I keep saying Jamal. I don't know. Do I have a friend who's Jamal? I keep saying it. But welcome, Barrister Jamala. It's good to have you. It's good to have you on the show. And yes, we've been looking at the talks of impeachment here in Rivers State. Remember, the assembly led by Martin Amaewhule-led, gave a 7-day ultimatum, and some people are now saying, if not, or how do they say it, or else, okay, if not or else, what will happen? And some people are guessing impeachment, and that's why the Attorney General and Commissioner for Justice has gone to a state high court asking the court to bar the CJ, that's the Chief Judge, Simeon Amadi, from taking any document that has to do with impeachment from the, what do you call it now, from the Martin Amaewhule-led assembly. Welcome back, Jamala. I apologize. But then my question before the break was, why go to a state high court asking such a request when you could have gone to court to declare that these people are illegal, like you have argued? Once again, welcome.
Thank you very much. Remember, there are pending cases that have to do with the legality of their membership of Rivers State House of Assembly.
Okay.
Those cases are pending.
Okay.
Now, why some belong to the school of thought that Section 109 is self-executory. Others belong to the school of thought that 109 is ambulatory.
Okay.
Now, in order not to, rather than sit on the fence, it's better you take some protective gears around yourself while acting in the state of government. And that is what the Attorney General of Rivers State has done. I may belong to the school of thought that Section 109 is self-executory.
Okay.
It is the court that will give the final interpretation to it. So if that be the case, and Section 188 that deals with impeachment procedures makes it mandatory for the state House of Assembly to have some communications with the Chief Judge of the state. And if that could be the leeway for me to move on, why shouldn't I exploit it?
Now, but get my point now. If you have said, now I'm going to throw this question at you now, and I believe your thought process may just be similar with what the state executive government is thinking. If that is the case, you have said this is an illegitimate government or legislative government.
My opinion.
I'm saying even because even the governor said yesterday that the legislative assembly he recognizes is the one led by Victor Okojumbo, right?
It's still an opinion until it's said so by the court of law.
But I'm going somewhere now. So the lawyers may have advised. You're also a lawyer. So if you're so certain, that means you will be able to prove your case in court, because remember, the court only would listen to or will look at evidence, right? And if the evidence in the Constitution is, so conspicuous, very much conspicuous, then there will be no need for us to go to a state high court, asking to bar this chief judge. Because then again, if in any way the court rules, now I'm thinking as a layman, if in any way the court rules any of the judgments, swings in favor of Martin, it means that they would have the right to start an impeachment process, and a judicial arm of government cannot stop the legislative arm of government from doing its work as prescribed by the Constitution.
I agree. By deriving their powers under the Constitution, they have every legislative right and function and powers to begin. I use the word begin an impeachment process, but it doesn't end with them.
True.
Alone, and that is why the chief judge of a state is also brought into the picture, who sets the 7-man panel committee, and it is a report of the committee that will determine whether or not the assembly will still pursue that process. And so if the report comes out in the negative, the process is dead on arrival.
All right.
Having said that, no matter the legal opinion you hold, you do not constitute a court of law.
True.
And so,
True.
whatever opinion that you have still have to be tested at the court of law. And it is only the court of law that has that powers to give a verdict. So no matter how sure I am of the facts, evidence before me, even I have 98%.
There is the 2%.
98, even if I have 100%, I am not in myself the court of law.
Interesting.
I still need to have the order of court to justify whatever opinion that I have. So that is exactly what is going on.
Okay. Do you agree that the judiciary, because I don't know, you said you were listening on your way here, you may have heard a certain Muriel and I think 2 other people who sent in WhatsApp messages say that the judiciary is the reason why we are immersed in these confusion or chaos. So do you think the judiciary, the state high court, federal high court, high court, do you think they're the reasons why we're here?
While I will not sit here to somehow protect or somehow say that the judiciary is not part of what we are facing through in this society, Nigeria generally, it is wrong to conclusively say that the judiciary has been the one that has brought us into this quagmire. It is not true. Now, the judges, if you look at the tenets of justice, is always blinded, right? Now, it is the evidence you bring before, let me use her, that makes her judgment. And so, because we are not privy, we do not have knowledge of how the court processes work. Look at the case pending in court. Okay, started in Court 4, Federal High Court 4, Port Harcourt. Now it has been transferred to Court 2.
Yeah,
now,
Court 2.
If you follow that procedure, that process, all those proceedings, you find out that there has always been a delay tactics from one of the parties. Do you blame the court in the circumstance? The right to fair hearing and use the both parties. And therefore, you cannot rush into giving justice and deny either of the parties the right to fair hearing. And that would tantamount to an injustice on the part of the person that you have not given fair hearing. So we must understand how the processes of courts works before we come out to make those conclusive way of denigrating the court.
Interesting.
I do not see the court. Yes, they are part of the no arm of the society, no segment of the society
is innocent.
Is innocent of everything that
including
Nigeria is made of. What Nigeria is made of is a combination of all the ills.
I want to try, I think it's time for me to open the phone lines, but I want to throw this question at you now. So if you're saying that the reason is because you cannot really tell as to where the pendulum will swing when it relates to a matter in court, and so the River State government, executive government, has gone to court just to ensure that it is in a safe place. The court barring, is an order, an interim order.
Yes.
Correct me if I'm wrong.
Interim order, yes.
So how does it work? An interim expires in 7 days. How does it work?
Interim orders are made pending the hearing of an interlocutory application, that is a motion on notice. Although the interim order expires in 7 days, the judge himself has a right to renew, extend, pending the hearing of that interlocutory application. Now, when that is done, and if the judge finds merit in the interlocutory application, that order lasts or subsists till the hearing of the substantive suit and judgment given. Oh,
so there's going to first of all be a hearing as it relates to the interlocutory injunction.
Yes, the interim order was made ex parte. In other words, the defendant respondents were never given the opportunity to hear because it was a matter of urgency. If you don't hear me now, the rest may likely be destroyed. So in order to protect the rest, the courts hear you ex parte, giving you the opportunity to go and serve the other person. The reliefs as contained in the ex parte are also the reliefs contained in the motion on notice. So that motion on notice gives the respondent the opportunity to defend himself, assuming the court was wrong in granting the ex parte. The respondent will bring reasons why the court should not grant that motion on notice. But if the reasons are not good enough, the court in the circumstance will go ahead to enter the interlocutory application, will subsist the substantive suit.
So if an interim order is given, I know where I'm going with this, because interim order and ex parte order has always been part of legal conversations in the past few months. So if an interim order is given, and let's say it empowers me to be the manager of this radio station, right? If the motion on notice is then heard by the court, and then I am wrong, me who went to court to ask for the ex parte order, I'm wrong, it doesn't mean that everything I have done within that period is null and void.
Remember, I said I can't lay my memory on the section of the Constitution and even the Electoral Act that talked about the presumption of regularity. Someone who acts in the position believing that he ordinarily has a right to act in that position electoral-wise, then all of a sudden it was found out that ab initio he lacked the powers to act. The actions taken, therefore, cannot be seen. You cannot reverse them.
You cannot reverse them.
Yes, most of the actions taken. Let's take the case of Rivers State, for example.
Interesting.
When Omeya came into power in 2007, the Supreme Court found out that he was wrongly brought into power by way of whatever election, and said Amechi ab initio was the authentic candidate. The actions of Omeya that signed some of their contract with Rivers State government,
employed people, paid salaries.
Pay salaries. Can you reverse those things? Declarative reliefs most times are reliefs that you cannot stay. So they became active upon the order given. So some of these actions you may not, but from the day the judgment or the order is given, you cease to function in the capacity that you may have derived by the motion on ex parte.
All right. Okay. So on X, I asked the question: do you think the Rivers State government, should find the need to go to court to stop Amaewhule-led assembly from initiating an impeachment process, given that there is the argument from their side that the assembly is illegal? And someone on X, Peter Chisom Okere, says, if need be. Oh, you could also go on X and drop your comments, but let's look at what people on Facebook are saying. Amechi Ezekiel says the government shouldn't worry for anything. Their illegality won't get anywhere. Their gathering is mere social. But the lawyer said you should be careful because the pendulum can swing anyway. Even though you have all your facts, you still need to prove. And this one says, Kalada, now I know the reason why they said, okay, I'm going to skip that part. He said, is the state assembly a family business that one can go off and on? Amaewhule should have considered the implications before defecting or resigning from the assembly, even if it was not documented but orally accepted. I think the judiciary should take the blame for not standing on the truth, but diverse and contradictory emphasis. The judiciary system has failed Rivers people and Nigeria at large. God help us. Daniel Okuku with that one. And Charlie Man Obiano Zie says, the impeachment threat by Amaewhule is an exercise in futility. The governor should not be worried about those frivolities. All right. More comments therein, but I'm just going to go to the phone lines now. 0817-923-0002, 0817-923-0003, 0817-923-0007. Those are the three numbers you can call me with right now and air your views on the issue, on the review. Once again, 0817-923-0002, 0817-923-0003, and 0817-923-0007. WhatsApp number 0809-030-6416. All right, let's look at some WhatsApp messages. It said, by your association with lawyers, you are now a lawyer or friend of the lawyers. Like I said, this is Nigeria. So the Attorney General of Rivers State approaching the court is not a bad thing. A judge in Abuja declared the current chief of staff wanted and reversed the decision and said that he was misled. The question to you who are you going to blame if anything happens to him by that first decision or of declaring wanted? So to me, it is good for the Attorney General to approach the court for self-defense. If you so with that one. Okay, I've got a question for you, but I hope I remember it when I do come back. This one says, what is the process of defection? I am Mrs. Uche. I think we've explained that. I'll explain it again. This one says, greetings to Jamal Esquire. Your guest has reaffirmed the position of the law in respect of what becomes of the members of the Rivers State House of Assembly after the defection of Amaewhule and his friends. Section 95, subsection 1 of the extant constitution empowers the remaining members to elect for themselves a member to preside over the sitting of the House by the imprimatur of the order of his lordship, Danagogo J. Edison Eye, presided and activated section 109, subsection 2 of the constitution. The operating word is shall, which imports mandatory compliance. Amaewhule and his friends should not be allowed to hold Rivers State and her people to ransom. Donato Saro Mene Mark Esquire, Port Harcourt. I've got who's first? I've got Gift from Yenagua. Gift, welcome. What is on your mind? Please go straight to the point.
Canada.
Yeah, greetings to you.
Good afternoon.
Yeah, good afternoon.
My happiness yesterday, I listened to your guest, just as I've listened to another guest today. We all know our stance. Whether you're a lawyer, you're not a lawyer, we know our stance. But the truth of the matter is this. You remember the time of Goodluck Ebele Jonathan?
What happened?
When they are using this word, automatic, I laugh at all of us. It's not automatic, and I want to prove it now. Number one, defected as a Speaker of House of Representatives with other PDP members. There was nothing like self-executory that they are talking about. Even the son that you, it is not you, I think Andrew called the other day, Idausa from Abuja, that is from Edo State, said it clearly. But most times you will see some of us, even the Falana that was talking about automatic. Automatic where? As I speak with you right now, in Abia State, lawmakers defected from PDP to Labour Party. It is not automatic,
All right, then.
as I speak with you.
All right.
In Enugu State, Labour Party members defected to PDP. It is not automatic.
All right. Gift, I've got to go.
State, what are we saying? Why are we always trying to push the law? As far as I'm concerned, that is the reason why the governor and the attorney general, that I am using the word that is not attorney general, ran to court, and that will not change anything. After 7 days, because of what Justice Omotosho did, there is nothing like anything project in Rivers State.
All right. Gift.
No law.
Gift, I've got to go. I've got to
There
go.
is no project.
All right, we've heard you. We've heard you. We're not quarreling. We're having a conversation. All right, thank you. Bright from Rumudumaya. Rumudumaya, I beg your pardon. Bright, welcome. What is on your mind?
Thank you. Evening.
Yeah, welcome.
I want to say something, concerning this issue.
That's why you're calling.
And the other House of Assembly members, based on the judgment. Well, my question is just like the question you have asked your guest. That how come they say they are not recognized, and the same government went to court to seek for judgment for them not to be impeached, for him not to be impeached. And before now, I think that was about 3 o'clock, also still on this station. A lawyer has also come to explain the process of impeachment. When you follow that process, I believe it will go even more than 1 month before they will impeach a governor. So how come they say they are not recognized, and they also went to court to seek for judgment that will make the chief judge and the clerk not to accept any letter from Martin Amaewhule House of Assembly. So I believe that they are recognized, and from Court of Appeal, that everything that the High Court have said since the last jurisdiction will not stand. And if the last jurisdiction to say anything, and when you are not qualified, whatever you say based on that process is not avoid.
All right.
So I believe that they are recognized. Martin Amaewhule is the speaker.
All right, and tell your opinion there. Harry from Port Harcourt. Harry, welcome. What is on your mind? I'd like to hear from you.
Yes, my brother Kalada.
Yeah, Harry.
Good evening.
All of the above. Good afternoon from my hand.
Yes, thank you for having me. My brother, see, Mike, I tell you, is the Martin Amaewhule fashion of group. They are not recognized again. No matter what thing they do, we know say they are hurt and they are hurt. This way they call gifts, they call the anger.
No, we don't do that. We don't. Everybody is entitled to expressing himself or herself. So please move on with your opinion, please.
But we know, you know, everybody know, the guests in your studio know that these people, they are out. Thank you. Gifts have to be very, very careful.
Anyways, thank you very much, Harry. I don't do that on my show, please. Let's make sure we know what we're doing when we call in. But back to you, Jamala Esquire. I want to ask this question. Now, 2 houses sitting for plenary. I mean, we saw 2 houses sit yesterday. Although you have said, according to the Constitution, it's supposed to be automatic, when you defect and you've not followed the right, like there is no division in your party or a merger. However, some people believe that it's not automatic. Before I get to both houses, can the judiciary pick who is a speaker? Can the judiciary come? Can the court come and say, Jamal, you're a member representing Asari Toro local government area, I pronounce you speaker? Can the court do that?
It doesn't lie within the powers of the judiciary to elect a speaker for the other tier of government, being the other arm of government, being the legislative arm of government. What the court did, let me answer you directly, is by recognizing this set of persons as lawful members of River State House of Assembly. The court never elected a speaker.
No. When you say, because we, for instance, we tried to the Federal High Court when you said Martin was the one who went to court. That's why. So, because we have been saying, the court declared him speaker. The court didn't declare him speaker. Okay. The court reaffirmed the position that he has been parading himself. Then Edison, did the court declare him speaker? The court did not declare him speaker. It was an election of those members of the House. Pursuant to the recognition by the court of law. If the court did not declare him speaker, at the time when he went to court, did the court say Martin and co were not members of the House? Because the court also did not say so. Let's not bring into the ruling of court made ex parte what was never there. Oh, I see. The court only made pronouncement as to the status of those who came before him. But that's why. See, now I'm looking at the legality now. Yes. We're learning on the show, right? And I'm saying yes, it was an ex parte. The other people did not have a chance to defend themselves. But the question then is, did the court have the right to say those other people are no longer members on an interim order? Remember that order has been set aside by the Court of Appeal. Now the court the order of my Lord C.N. Wali. No, I'm not. I'm looking at Justice Danagogo. Danagogo's case. That's where the ex parte order was gotten recognizing from. These other set of persons. Yes, I remember that suit has been withdrawn. So that's where the problem is. So I'm yet again asking, because it also is contributing to this, because we now have 2 houses of assembly, and one is having root from Justice Danagogo's court, and the other is having its root from the Federal High Court. So I'm not wondering, can the court say, Edison, here your speaker? The court can't say so. I see. The court can only recognize whether they are members of the House of Assembly. It is a function, responsibility, and duty of members of the House to elect for themselves a speaker. It is not the duty of the court. But why the question or the issue of their legal status is pending? Remember, like I said, it's before the Federal High Court, Port Harcourt. 3 cases bordering on that. But sorry, can I pause you still, because I still have I'm still a bit confused. So if the court only ruled that Danagogo ex parte order was on their membership, the legality of Edison and co. Not whether they are in the circumstances can be seen to be members of. Remember, the substantive suit was never heard. So that's what I'm saying. So the legality now. Okay, let's say I'm using the wrong word now. So if they're still members, but that means 4 of them cannot vote a speaker, because we still have this odd 26 that there was no case head on. If you are coming from the understanding that this set of persons having defected, let me use this opportunity to answer gifts. In those states that he made references to, those states, the speaker never declared those seats vacant. So he cannot, in all true conscience, bring that into play from what is happening in River State. It is subsection 2 that makes the speaker to do so. But when in the circumstance of River State, the speaker himself also defected. Now, the person who emerged as the Speaker of the House, as nature abhors vacuum,
activated section.
That's what I'm saying. Where's the vacuum? Because there is no. Oh, anyways, my time is up. I wish we could continue with this conversation because I'm trying to understand how if four say they're still members and 26 no court says they are no longer members. Where are we getting all of this confusion from? But maybe we'll call Jamal at some other time. We'll continue the conversation and we'll talk about this because it's been an exciting conversation and I want to thank you.
Thank you very much for having me. Always a pleasure.
All right, then. Leaving Jamal Esquire, my guest for now. Commercial break. After that, news update. Do stay tuned.
For more talk,